Every once in a while you read about people in your community who rise above the norm, and that would be the case of Carrie Leonetti. She is here today. She's headed to Central or Eastern Europe as a Fulbright scholar. Congratulations, and thanks for coming in today. First of all, explain what a Fulbright is. Why is this so special?
The Fulbright program is administered by CIES, which I think is a subdivision of the State Department. It's part of the United States diplomatic outreach to other countries that we sponsor scholars to go to other countries to teach and do research as part of scholarly exchanges.
And so what are you going to be doing in this, in the former Yugoslavia?
I'm going to be doing two things. I'm going to be teaching on the Faculty of Criminal Justice at the University of Sarajevo, teaching primarily criminal procedure and forensic science classes. And then I'll also be doing research and writing on issues involving eyewitness identification.
Yeah, that is a big issue over there. And why is this such a, why is this of interest to you?
So there are several things that are interesting about eyewitness identification in Bosnia. For me, the most interesting thing is that the Bosnian Herzegovinian Penal Code has a series of very stringent restrictions on the admissibility of eyewitness identification, unlike laws in the United States. We tend to be fairly lenient in admitting eyewitness identifications in trial and allowing juries to decide whether they believe the witnesses or not. But the Bosnian Herzegovinian Code embeds certain sort of procedural requirements that have to be met before eyewitnesses are permitted to testify in court there to identify suspects or perpetrators of crimes.
Now, so, why is this so important in the research that you're doing over there?
Well, it's important for a series of reasons. First of all, one thing that's interesting about the code is it was drafted in the wake of the Dayton settlement of the Civil War, the Bosnian Civil War, or the former Yugoslavian Civil War in 1995. One of the assumptions I'm making is it was probably drafted with the help of foreign legal scholars. I don't think that these restrictions on eyewitness identification are sort of organic to Central Europe or even to the inquisitorial legal system that they have there. So one thing that interests me is it seems that we have probably, in our role in helping to settle their conflict, encourage them or help them to draft some restrictions on eyewitness identification that we don't have in our country. And so it creates an interesting contrast. One of the things that DNA has taught us in the United States criminal justice system is that a lot of the times that innocent people are subsequently exonerated by DNA evidence, faulty eyewitness identification has played a role in their conviction. According to the Innocence Project, I think well over half of faulty convictions that have been subsequently undone by DNA have involved erroneous eyewitness identification in U.S. trials. So it's interesting to me to study a system that adopts a lot of the reforms that we don't have in our country for faulty eyewitness identifications. It's an interesting contrast.
So are you going to take DNA technology into the courtrooms over there, or you hope to present it in...
No, my research actually doesn't have anything to do with DNA. I'm much more interested in this statute that they have. If you looked at the Innocence Project, for instance, they would have a wish list of things we ought to do differently in our country with eyewitness identification. A lot of those have been adopted in Bosnia. And so I'm interested in how that came about. I'm interested in whether it's followed, whether it's resented, and what kind of impact it has on their trials. In Bosnia, an eyewitness who can't meet these reliability requirements doesn't get to testify to their eyewitness identification in court. And so I'm curious, does that make their trials more reliable or less reliable than ours, where largely eyewitnesses get to testify no matter what, and the jury decides to believe them or not?
So you're going to be gone next school year doing this project in this area of law. And what do you hope to bring back to the classroom?
Well, first of all, the Bosnian legal system is largely what's called inquisitorial. The United States is fairly unique in having an adversarial system of justice. So the idea of having in a criminal trial a prosecutor and a defense attorney who are adversaries, who cross-examine one another's witnesses, who do their own investigations, that's a fairly United States phenomenon. That's not at all how trials occur in Europe. So one thing that's interesting is to...
We have about 15 seconds.
Okay, is to see how the rules of evidence work out in an inquisitorial system, and if there's anything that it can teach us about our system of justice. We seem to influence them to become more adversarial, but it's interesting to me to see what the inquisitorial system has to teach us.
Okay, Carrie, it sounds very fascinating. Good luck with your project.
Thank you.